Good afternoon and welcome to today's webinar, What Legal Tool is Right for Me and My Family? My name is Juliana Valencia. I am the supervisor for the Caregiver and Supportive Services Unit with Fairfax Area Agency on Aging. You should have received an email this morning with the speaker's slides, so you'll have them for reference in the future. Now, before I introduce today's speaker, I will go over a few housekeeping items. There is a Q&A button where you can submit your questions or any concerns that you have throughout the presentation. We are going to allocate a few minutes today for those questions. In addition to that, if you could go ahead and fill out our survey that we have at the end of the presentation, that would be wonderful. Now, before I go over other housekeeping items, I want to let you know that we do have a closed captioning, so it has been enabled if you need to use it. And now I would like to introduce Denise Pitts, who graduated from the University of South Carolina Law School, and she has approximately 30 years of experience. Denise has been a state prosecutor in North Carolina and Texas, and she has practiced criminal defense, wills and trusts law, collection law, bankruptcy law, consumer protection law, housing law, and elder law. She is currently the Director of Consumer Practice and Elder Law Attorney in the Fairfax Office of Legal Services of Northern Virginia. Welcome, Denise, and thank you so much for being here.
Thank you. I appreciate that introduction. Can you all hear me?
Yes,
Okay.
We can hear you.
Okay. Thank you all for being here. I hope you find this informative. I'm happy to be here and to present to you. And I'm going to share my screen and share some information that I've prepared. So if you bear with me. Okay. Thank you. So Legal Services of Northern Virginia is a nonprofit law firm. We have about 44 attorneys and we have approximately 40 support staff and paralegals. Our mission is to provide access to justice for disadvantaged individuals and communities. So we provide free legal services, and as a general rule, our services are free to low income and underserved members of our community, and we serve the residents of Northern Virginia. And this is actually our 41st year. I want to talk to you all about tools that you may find helpful in caring for your loved ones. And some of these tools are applicable no matter what your age is, and I would argue most of them are applicable regardless of your age. And I want to talk about a general durable power of attorney. That is my go-to recommendation for everyone. That you may not have an estate plan, you may not have a will, but you should have a general durable power of attorney. What is a general durable power of attorney? It is a document. It's between a principal and an agent, and the principal is the person who creates the document, and the agent is the person to whom the power is given. It allows the person to step into the shoes of the principal, so that the agent can act on behalf of the principal when the principal is unwilling or unable to act for themselves. A general durable power of attorney generally gives very broad powers to the agent, so that the agent can do anything a principal can do, such as handling personal and financial affairs, and remains in effect even if the principal becomes incapacitated. So if you get a general durable power of attorney, it's easy, it's relatively inexpensive, and it will prevent the need to go to court to petition the court for guardianship if someone becomes incapacitated. Just because as a general rule, we give broad powers doesn't mean that if you're interested in executing a power of attorney, doesn't mean you have to give all those powers. You can give a very limited or special power of attorney. For instance, give the power of attorney to a parent or a son or a daughter to sell your car or to sell a home, or a very discrete task. Understand that if you sign a general durable power of attorney, it doesn't mean that you've given up any rights or that you can no longer make decisions or that you're no longer taking care of your affairs. As long as you have capacity, your agent should only act on your behalf when asked by you. When is it effective? When does it terminate? A general durable power of attorney will take effect on the date you sign it, unless you execute a springing power of an attorney. And as the title sort of conveys, a springing power of attorney springs into effect upon the occurrence of an event. And that event is you no longer have capacity. The problem with a springing power of attorney is when you no longer have capacity, two doctors have to examine you and render a written opinion that you're unable to handle your affairs. And if that occurs, it's generally a critical time for your family. So if you can do a general durable power of attorney that's immediately effective, I think it's a much easier tool to have in place, and for your agent to use and for your family to activate. So a power of attorney remains in effect during your lifetime unless you revoke it or you build in specific language that terminates the power of attorney on a certain date or upon the occurrence of an event, such as you have the power of attorney to sell a car, the car is sold, the power of attorney extinguishes. The power of attorney is also not effective any longer when the principal dies or the agent dies or resigns or becomes incapacitated and there is no surviving substitute or co-agent. So let me break that down a little bit more. When I draft a general durable power of attorney for a client, I recommend that the principal appoints an agent and then a substitute agent or a co-agent. So if you have two children that get along relatively well, you can appoint those two children as co-agents, or you could appoint one child as a co-agent and the second child as a substitute agent. And the language is very specific, and it will say, if my agent is unwilling to act, then I direct that my substitute agent step in and have all the powers enumerated in this document. Additionally, you can change a power of attorney anytime. I recommend that you don't try to do that yourself, that you return to the attorney that drafted it for you. And of course, to change a power of attorney, you have to be competent. You have to have legal capacity. What kind of authorities does it give to agents? People are always surprised at the wide range of powers. And you can see from the list that it's very comprehensive. And in short, a power of attorney gives your agent the power to do anything you could do, including handling real property, tangible personal property, stocks, bonds, commodities, options, do your banking, conduct business operations, make changes to your insurance and annuities, administer look out for your interests that you may get through probate or a trust. Your agent can file litigation for you. Your agent picks the clothes you're going to wear, can direct that somebody cook you the food that they think you're going to want. They can apply for government benefits. They can make changes to retirement plans. They can file taxes, and they can also take care of gifts. A lot of clients look at me like I'm crazy, and they're like, I have none of those things. I just want someone to close my bank account when or to write checks for me if I'm hit by a bus. And I say, while you have capacity, let's plan for the worst and hope for the best. So while some of these options don't apply to you, it's always best to make a provision for them, because you might win the lottery at some point or get a huge inheritance. We just don't know what life holds for us from one day to the next. And again, as an attorney, I plan for the worst and hope for the best. What can the agent not do? The agent can't make medical decisions for you. And I'm going to come back to that. They can't do anything that's limited in the power of attorney document. And they have to look out for your best interests. A durable power of attorney creates a fiduciary duty for the agent, which means they're held to a very high duty of care in taking care of your business things. So they do have to look out for your best interests. You may be thinking, well, wait, I want my power of attorney. I want my agent to be able to make medical decisions for me in case I am hit by a bus and I can't speak for myself. Don't worry. We can execute a healthcare power of attorney. As a general rule, a regular power of attorney should not contain medical directives that the principal wishes in the event that they're incapacitated. As a general rule, there should be a second document addressing medical decisions. How do you pick an agent? So first of all, if you have to pick an agent, you can't do a power of attorney and say, I don't have anyone to act for me. So how do you pick an agent? It's so important that you pick someone that you completely trust, because that person is going to be able to write checks on your behalf, to file taxes. The list goes on. And again, there's good reason for making it a comprehensive list. I don't think if you're worried about giving an agent all of those powers, it means you haven't found the person that you completely trust. That person has to be over 18 years of age and has to have legal capacity. They have to be competent. I always try to get clients to name more than one agent. I've already touched on this. This comes in the form of a substitute agent or a co-agent. Sometimes it's cleaner to just do a co-agent or a substitute agent. So then you don't have to worry about your co-agents fighting or disagreeing about what you might want or what's in your best interest. If you do a power of attorney, which I'm telling everyone needs one regardless of age, be sure to discuss the person you name as agent, and make sure that person is willing to act as the agent and take care of your business if it becomes necessary. Being an agent should never come as a surprise to the agent. How do I get one? How do you get a power of attorney? So hopefully you go to an attorney and you get it drafted. Again, it's simple. It's not an expensive document. It's very important. So I don't recommend that you pick something off of Google that you find. Spend the $200 or whatever, or come to legal services, and I'll talk more about that in a moment. But it has to be signed by the principal, and it has to be notarized. It has to be witnessed by two people that are not your agents or don't have an interest in the power of attorney. Again, a lawyer should write this for you. You should go to an attorney. You want to make sure it complies with the laws of Virginia. I recently had a case where a client came to me and said, yeah, I have this power of attorney, and the Social Security Administration won't take it. And I said, that's odd. Why don't you send me the power of attorney? And I looked at the power of attorney, and sure enough, it was improperly drafted, so that no one was ever going to accept it, because it was just an ineffective document. And at the bottom, it did say like legal depot or law depot. So this person took a document off of the internet and got halfway there, got it half done. But you don't want to have a half done general durable power of attorney. It's kind of like you're either pregnant or you're not. You either have a power of attorney or you don't. So I'm not trying to drum up business, but I do recommend that you have an attorney draft it for you. So your local legal aid office may be able to provide a power of attorney for you if you're eligible for legal aid. Here in Fairfax, I am a legal aid attorney and I do elder law. And because Fairfax County gives a grant to Legal Services of Northern Virginia, I am able to speak with any person over the age of 60, regardless of income. And so it may be that I won't represent you in a complicated case if you're way over income, but a power of attorney is such an easy document for me to prepare that I can usually get it done quickly, and I'm happy to do it for people regardless of their income. If you have a complicated estate, in that you're trying to provide for a disabled child or provide for minor children, then I would recommend that you do see a private attorney, because you have a more complicated estate. And chances are, if you are trying to provide for a minor child or a disabled child or a disabled sibling, you're going to need a trust. And I don't have the expertise to draft a trust. So suppose you come to me and you get your power of attorney. What do you do with it? What do you do with that physical document once you get it? One, you keep it in a safe place. Most places will accept a copy. So, but you don't want to just hand out copies willy-nilly in case you need to revoke it. You want to give a copy to your agent. Again, that kind of obviates any surprise. Your agent will know they're the agent, and hopefully they know they're the agent before you even start drafting. What happens if you don't have a general durable power of attorney and you don't have capacity? Or suppose you're married and your husband doesn't give the husband doesn't give the wife a power of attorney and gets hit by a bus and is in a coma, and is unable to speak for themselves. If you don't have a power of attorney, you're going to have to get a guardianship. And if you have a healthy income stream, you're going to need a conservatorship. And As you're going to see, it's a not very complicated process. It's a lengthy process. I don't think you can do it on your own. I do think you need an attorney to represent you. Because we're legal aid, I get about 1 case a week from the judges at Fairfax County Circuit Court who are asking me to step in and help someone who has tried to do a guardianship or conservatorship themselves. Again, you can prevent all of this by executing a power of attorney. What is a guardianship or power of attorney or conservatorship? So a guardianship or a guardian takes care of the person, and a conservator takes care of the money that person has. You have to go to court, file documents petitioning the court to appoint a guardian and or a conservator. You have to have medical records filed in court, which then become public records. And then the court will determine whether or not that person is incapacitated and needs to have a substitute decision maker to meet their needs. The incapacitated person is called the respondent, and the person trying to get the guardianship is called the petitioner. What is a guardian? So a guardian is, we hear that word used a lot, but in this context, it's a term of art, and it refers to an individual who is appointed by the court to bear the responsibility for the personal affairs of the incapacitated person, such as housing, healthcare, or therapeutic treatment. I see a lot of clients who come to me seeking a guardianship because they waited too long to get a power of attorney. Their loved one no longer has legal capacity, and they might be wrangling with the housing authority or Social Security Administration, and Medicaid, Medicare. And as you can well imagine, some of these organizations are pretty strict about not taking any action until a guardian is appointed. And generally that's a 3 to 4 month process. Something has happened. I don't know if it was, Britney Spears being in the news, but I am swamped with guardianships. I have done 24 this year to date. I have 6 pending in court, and I've got a list of 14 people waiting for me to begin their work. I don't know what happened. What's a conservator? A conservator we're using as a term of art in this case, and it's a person appointed by the court to manage the state and financial affairs of the incapacitated person. Who can be appointed guardian or conservator? Often the person who files for petition or conservatorship is appointed as the guardian and or conservator. You can be both, okay? Usually the petitioner, the person who wants to be the guardian, is a family member or very close friend. You have to be 18 years of age and capable of performing the tasks. If you're trying to be a conservator, you're going to need to post a bond. So if you have a bankruptcy in your past, it may be difficult to become a conservator. It's not impossible, but just in the interest of full disclosure, it does become a little bit more difficult. You are not required to be a guardian or a resident of Virginia in order to be the guardian or conservator. Obviously, it's much easier to be a guardian of someone who resides in Virginia, if you reside in Virginia, because the law does require periodic visits if you're the guardian over someone. But again, it's not impossible to be from out of state. What does the term incapacitated person mean under Virginia law? An incapacitated person is defined under Virginia law. I have my picture blocking some of the language. So if I'm not reading it correctly, it's because my face, I can't get rid of my face on this meeting. But an incapacitated person is defined under Virginia law as an adult who has been found by the court to be incapable of receiving or evaluating information effectively, or of responding to events or their environment to such an extent that they lack the capacity to meet the essential requirements for your care, health, safety, or therapeutic needs without the assistance or protection of a guardian, or to manage property or financial affairs for your own support or for the support of dependents without the protection of a conservator. So under Virginia law, poor judgment alone is not a reason for finding a person incapacitated. I spoke with an applicant yesterday. She's married to a man who is quickly depleting their life savings by falling for scams. And it's the scam where you're contacted and told that you've won a large cash prize or a car, but you need to pay like a $300 delivery fee. And they want that delivery fee in checks or in gift cards. This man has lost $90,000 and there's no way I can get it back. Furthermore, that is what I mean by poor judgment alone does not render a person incapacitated. This person has been examined to determine if he has capacity, and he has legal capacity, and a judge isn't going to award or put him under a conservatorship. And even if he does, even if this person is put under a conservatorship, how is that wife going to stop him from getting on his phone and reaching out to these scammers? And even though he spent $90,000 trying to collect cash prizes and cars and what have you, and has gotten nothing, he still tells his wife, like, this is the one, this one is real. It's sad. What is the procedure for having the court appoint a guardianship or conservator? So first of all, you have to file a petition for the appointment of a guardianship or a conservatorship in circuit court in the county where the person has lived for 6 months. You have to file a report with that petition from a doctor saying that the person can no longer make their own decisions or care for themselves. And the report has to say it's the doctor's belief that this report is this diagnosis will last for the person's lifetime and does not show any promise of getting better. So here's some additional things that the petitioner, the one trying to get the guardianship, will have to submit. The attorney writes a description of the nature, type, and extent of the respondent's incapacity and specific functional impairments. It's not uncommon for me to have a list in the petition saying the respondent is confined to a wheelchair. The respondent has lost the ability to speak. The respondent has lost the ability to transfer from bed to chair. The respondent needs assistance toileting. So the list is as long as the list is. And again, this becomes a public record. So people don't like that, but just another reason to get a power of attorney before it's too late. The diagnosis from the doctor has to be in there. The dates of examinations, evaluations, and assessments have to be included. And the signature of the person conducting the evaluation. So this can just be one doctor's note, letter, and I can enumerate on not the directions in paragraph 1 in the petition based on interviews with the petitioner. What is the court procedure? So the respondent will be given notice that the petitioner that the petition has been filed. First of all, though, the court will appoint a guardian ad litem, and it's all often abbreviated a GAL, and that person is not the respondent's attorney. Rather, it is an attorney appointed to represent the rights and best interests of the respondent or the proposed incapacitated person. The guardian ad litem will come and meet with the proposed incapacitated person, whether or not they can understand what's going on. If they're in a comatose state, it's an odd meeting with the guardian ad litem talking to and asking questions to a comatose person, but it has to be done. And then they will present a report saying whether or not they agree with the petition that a guardianship or a conservatorship is in the best interest. And it costs $20 to file, which is one of the cheapest filings in circuit court. Finally, after the GAL prepares a report, the court will hold a hearing. The respondent has the right to be there. Frequently, the guardian ad litem waives that person's right to come to the hearing and participate, because if they're in a comatose state, obviously there's difficulties in transporting someone in that medical condition to court. And more importantly, they will have nothing to contribute. So it's a lot of work for not a lot of benefit. The court can issue a limited conservatorship or guardianship. As a general rule, LSNV only takes on uncontested guardianships and conservatorships. And when they're uncontested, the hearing takes place right in front of the judge's bench and is less than 5 minutes. And then you go to probate and you get papers saying you've been appointed the guardian or the conservator, and you're good to go. It's a lengthy process. It can take 2 to 6 months. With the workload I'm working with, my estimate that I give to clients is 6 months. How does the court set bond when a person is petitioning for guardian or conservator, and whose money can be used to pay the bond? When a conservator, and again, that's the person taking care of the money, is appointed, the guardian ad litem will gather up all the assets and add them together and come up with an estimate, which includes the next year of estimated income. And the bond will be set at 1.5 to 2 times that figure. the incapacitated person's estate can be used, their money can be used to post that bond. As a general rule, in guardianship cases, no bond is required, no surety is required. So the person appointed guardianship has duties relative to the guardianship or conservatorship. In general, a guardian is responsible for the health, medical needs, and general well-being of the respondent, and the conservator handles the person's property, a home, and finances. Fiduciary duty. So I think I mentioned this. I didn't go into much detail, but it's just a standard of care that you will be held to if you are appointed the guardian or conservator over a loved one. And that means that you're obligated to do what is in the incapacitated person's best interests. You have to file reports annually. For a guardian, that report addresses the care and living conditions of the incapacitated person. The conservator files a financial accounting, which simply lists and explains the money you've spent on behalf of the incapacitated person. And the probate department in Fairfax County is very helpful in helping you file that. Here's a list of what your report to the Department of Social Services shall include. Again, it's very easy to get help. Don't say, I'm not going to get a guardianship because it's too much work. Then you're going to get between a rock and a hard place when Social Security or Medicaid is asking for that guardianship. So as a general rule, a guardian or conservator is allowed reasonable compensation and reimbursement for reasonable expenses. And that can come out of the incapacitated person's income or savings. It's for the cases I have, it's not unusual for there to be no money to compensate the guardian or conservator. You, as the guardian or conservator, you can get up to $125 an hour for 5 hours per month. So you're not going to get rich being a guardian. If you're both, you don't get a separate fee for work as the guardian and work as the conservator. You should keep a log of your expenses. And you'll be compensated at a reasonable rate. This doesn't have to be a court-ordered rate. You can determine the rate. It should be under $125. Keep a log, keep records in case you're audited. What are the disadvantages to a guardianship? So a guardianship or conservatorship is a last resort. These proceedings take away the incapacitated person's fundamental right of self-determination. They give up the right to drive, to vote, to own a handgun. The proceedings are time-consuming, and unless you have a legal aid attorney, they can be quite expensive. If they're contested, you're going to have to pay expert fees. The court decides who's going to be the substitute decision maker, not you before you were incapacitated. So it may not be the person you want or you would have chosen before you became incompetent. Alternatives, well, I hope you all know the answer to that. A general durable power of attorney is your best friend in an estate plan. In this case, you get to take care of everything before you become incapacitated. And again, you may die before you even become incapacitated. You may, get hit by a car, have a heart attack and be dead before the power of attorney is even used. But it's still important to get one. It's inexpensive and it's quick. I'm going to go through some frequently asked questions. Can a guardianship or conservatorship be terminated? Yes, of course. We can always undo things. If the incapacitated person dies, the conservatorship and guardianship automatically ends. Someone can petition circuit court to restore the respondent's legal capacity. If that happens, a new court case is going to be opened, a new hearing will be held, a guardian ad litem will file a new report, and the court will determine if the person has regained the ability to care for his or her own person, their estate, and financial affairs. Sometimes we do a temporary guardianship, and if that's the case, the guardianship or conservatorship will automatically end when this period has passed. So you don't have to go to court to extinguish it. What if you're a guardian and somebody disagrees with your decision? As a general rule, if you're acting in if you're observing your fiduciary duty and making sound decisions, you're not going to be held personally liable. If you sign a contract on behalf of an incapacitated person, make sure you're signing any legal document with your name, like Denise Pitts, as conservator for John Pitts. So I would be the conservator and John Pitts would be the incapacitated person. It's really important to keep scrupulous records. Can an incapacitated person make a will? Maybe. An incapacitated person only has to understand what he or she owns, and the mere fact that one is under a guardianship or conservatorship, if they're under a conservatorship alone, they probably still can make a will. But if they're under these, they still may have the capacity to make a will, unless the order says otherwise. Then they may be able to make a will. It's very important in a case like this to see an attorney. An attorney is going to really go through and determine capacity and draft documents very carefully to minimize objections to the will after the incapacitated person's death. If a guardian is appointed, will the incapacitated person be allowed to vote, drive, or have use of firearms? As a general rule, the answer is no, unless you have drafted an order that the judge has signed that allow the incapacitated person to retain those rights. As a general rule, the court's going to look long and hard at allowing an incapacitated person to retain any of those rights, and you should be prepared for a no answer from the judge. What if the incapacitated person lived in another state and is now living in Virginia? So you do have to transfer the guardianship. A good place to start getting that guardianship transferred is to call your local legal aid. At least you're going to get some advice and counsel. Also contact the probate department in the state where you're residing, or in the state where you have moved from. I have been practicing law for over 30 years, and I can tell you the probate department is the nicest department in the entire courthouse. They're used to dealing with non-attorneys, and they're very, very helpful. So don't forget they're a valuable resource. What if your ward doesn't want to move? The incapacitated person doesn't want to move. You're going to have to get court authorization to change their residence. And you need to do it before you change the residence of the person. Although, I wonder what the remedy would be if you move the person's residence, and no one objected. If no one objects, I don't know that you would have to have that court authorization, except it might be hard to transfer the guardianship without a court order saying you could move the incapacitated person. And I'm sorry, I feel like I'm getting into some deep weeds here. Can I use my ward's money for my own bills? Yes, you can, as long as it's reasonably related to your work. And you can apply the incapacitated person's money to their debt. What happens? I think I can't read that top, sorry. What happens? I think if no money is available to meet the respondent's needs, or I feel I cannot perform my duties. Again, like the power of attorney, I suggest that when you're petitioning the court to be a guardian, that you have a co-guardian or a standby guardian ready to jump in if you're unable to assist. And if there's no money to pay the bills, bills just don't get paid. Make sure you're signing as guardian or conservator so that you're not personally liable. What if the incapacitated person recovers and doesn't need a guardianship? Then you can revoke it if the circumstances are such that the guardian or conservator is no longer necessary or is insufficient. What if the incapacitated person doesn't want me to be their guardian anymore? The incapacitated person may file a petition to remove you as guardian. And at that point, the court will assess whether that person needs the guardian or conservatorship, the extent to which the guardian is managing the person's affairs, whether it's excessive or insufficient, and whether or not the incapacitated person has had a change in their understanding or their capacity so that they no longer need a guardian. You could find yourself out of a job. So if the incapacitated person doesn't want you to be a guardian anymore, there has to be a preponderance of the evidence that shows the person has substantially regained his ability to care for his person in the case of a guardianship, or manage and handle his estate in the case of a conservatorship. And a preponderance of evidence means it's more probable than not. So it's not the standard of care or the standard of proof like in a criminal case where it's beyond a reasonable doubt. In this type of a proceeding, it would be the preponderance of evidence, which shows that it's more probable than not. Am I allowed to engage in litigation, file lawsuits, or defend suits for my ward? Yes, you can. Okay, I see some questions, or I see numbers in the question. Juliana promised me she would help me with the questions.
Thank you so much, Denise. That was wonderful. And yes, we do have a few questions that I want to make sure we have time to address. So let's start with the first question. What if a principal has no one to serve as an agent? What options exist?
Sometimes if you have substantial assets, a bank or corporate fiduciary can be found, but more and more banks are getting out of the business of acting as powers of attorney. You really need someone to act for you.
Okay. So our next question says, what could you, or could you please talk about guardianship for people with serious mental health illnesses? What conditions qualify?
So this is a really difficult and tricky area of guardianship. A lot of people with mental disabilities have legal capacity. Like if you have an adult child who's schizophrenic, they're probably not a great candidate for a guardianship because one, they're going to contest it, and two, they have periods where they have capacity. And three, if you get a guardianship, which I don't think a judge will order, you still do not have the power to force medicine down that child's throat or to prevent them from leaving the home and not returning for a week, or to make them bathe or shower in a manner that you feel is appropriate. So for those type of mental disabilities where capacity can be on again, off again, a conservatorship is really not a great tool. I tell clients or applicants that come to me wanting help with their adult children or their parents or a sibling, that I can just provide resources and caseworkers, but a guardianship isn't going to solve or change anything. And it's hard, that advice is very hard to hear because they've generally been told by the police or the community services board or Social Security Administration, oh, call legal aid and get a guardianship, only to be then told that it's not going to be an effective tool.
Thank you, Denise. That was very helpful. So to clarify, is there no power of attorney and no one of if my parents die, I will not be able to make decisions on their behalf? I'm not sure if I understood that. Did you?
So a power of attorney is only effective when the principal is alive. As a general rule, if you don't have a power of attorney and you have a parent that's been hospitalized, the hospital is going to follow your wishes and allow you to speak on behalf of immediate family. They're not going to follow your wishes if you're speaking for a neighbor. But as a general rule, there's some leeway with family. So you will be able to, advocate for your parent who's in the hospital and say like, no, we don't want that operation. And the hospital will generally listen to you even without a power of attorney. The banks, no, not so much.
That's very different, right?
Yeah.
So my next question says, could you clarify how the court appoints a guardian? Do they consider family by default?
So the court appoints the guardian nominated in the petition. So what generally happens is a client will come to me and say, I'm taking care of my mother and she has Alzheimer's. She can't talk anymore. She doesn't even know who I am. So then I'll say, oh, okay, this sounds appropriate for a guardianship. Are you willing to be the guardian? And generally that person says yes. If that person says no, we're at an impasse. You cannot file a guardianship petition without nominating a guardian. And the court isn't going to interview 7 family members and pick one. The person that's going to be the guardian has to initiate the court proceeding.
And ideally, it will be a family member who truly knows you, I would think.
Yes.
So the next question says, is probate court's records, especially with will filings and asset list, a matter of public record? Is it only paper, so that a stranger may only access it by physically going to the courthouse? Or is it online, now available to any scammer? I'm concerned about scammers harassing or trying to trick my wife, or is it a trust the only solution to it?
So if you're worried about scammers scamming your wife, if you're in probate, presumably your wife has passed away. If you're in probate for the purposes of a guardianship, we can file, we're required to file some of the information under seal. which means it's when someone asks to see the file, those sealed documents are removed. And of course, they're the addendum containing the social security number. We can ask the court to seal anything with good cause. So right now, Fairfax County, you cannot access a lot of these documents online. You have to go and request to actually have the physical file pulled. And then you have to sit in a certain room in the courthouse and review it. And no pictures are allowed. But it's still, I mean, mostly it's attorneys in that room, and they're taking notes on what they see in the file. They can also ask for copies of documents in the file. You just have to be vigilant against scammers.
That's scary.
It is scary.
So technically anyone could request those documents if they knew that these documents exist.
Right.
What would be a solution to kind of prevent people from accessing those type of documents?
I mean, don't tell people what you're doing. Y'all may think I'm crazy, but I've unplugged my Alexa because I don't want her hearing what I'm talking about. And I've had too many occasions where I've said to my husband, let's go to the Galapagos. And then an hour later, I pick up my cell phone and I'm being slammed with vacation arrangements to the Galapagos. So I'm very careful about what I have in my house that can hear me. Don't tell neighbors what you're doing. Don't discuss your personal affairs with anyone. If you become a guardian, nobody has to know you're a guardian. Just be as discreet as you can with your information.
Thank you. That's very important. Thank you for saying that. So the next question says, does power of attorney cancel out a trust?
No. So here's the deal. A power of attorney is only effective during your life. When you draw your last breath, the power of attorney, the fire goes out and it's gone. The trust kicks in at that point. At the point that you die, the trust kicks in. So they're complementary, but they're mutually exclusive.
Okay, that's good to know. So what is the difference with the medical directive? Is there power of attorney, would that supersede the medical directive?
So a power of attorney takes care of all your finances, all of your personal property, like your house, your investments, your checking account. A healthcare power of attorney, not surprisingly, addresses your healthcare. And they have to be two separate documents. So if you have really strong wishes about whether or not you want to undergo chemotherapy, like you're 89, and you think, if I get cancer, I'm just gonna not have treatment except for palliative care, that has to be in a healthcare power of attorney. And of course, as long as you have capacity, you can speak up and say what you want. But planning for the worst, you should have a healthcare power of attorney that says what you want to happen in the event that you do get cancer at an advanced age.
Okay, and I think you have talked already about the next question, but I'm just going to ask her if there is something that you want to clarify there. Does a spouse automatically becomes a general power of attorney, guardian, and conservator for each state?
No. You are nothing to each other except perhaps legally married. In order to become the agent under a power of attorney, which if you become the agent, you won't need a guardianship or conservatorship, but you have to take affirmative action to become an agent or to activate a power of attorney. There is no case anywhere in the world, and I mean the world, that's a bold statement, where a power of attorney springs into effect as a result of being married. It doesn't happen. It's a document that you have to affirmatively seek out, sign, execute, and activate. Nowhere in the world.
Okay, good to know. Is the income that you earn as a guardian or conservator taxable?
Yes. But again, you can't make more than what, $525 or $625 a month. So yes, it's taxable, but it's not going to be a huge tax liability. And for the clients that I work with, it's that money is allowing them to keep the lights on and to buy food. It's essential if it's there.
Okay.
So don't not take it because of the tax implication.
Okay. Are there any suggestions for a person with limited social support? Someone who doesn't have a family member or a friend who could be named as a power of attorney?
I suggest if a person is in that situation that they get a caseworker through social services, whether or not they need one, or if they barely need one, get one so you have someone, some support, someone checking on you, even if it's just once a month. Reach out to people in your church, join a church if you don't have one, to as a way to provide for yourself, as a way to set up someone that's going to make sure you're waking up every morning. And I know that sounds so morbid, and I'm sorry if I'm offending people with talk of advanced cancer and getting hit by buses and making sure you didn't die in your sleep, but I just feel like we have to talk about the elephant in the room.
Okay. So another question says, guardian and conservatorship was granted in Virginia. Petitioner was brought in from out of state 18 months ago or a while ago. Can I inquire on petitioner's out of state financial accounts in out of state financial institutions?
So I'm assuming that question where they say petitioner, they mean respondents, because that only makes sense if they're talking about the incapacitated person has been brought to the state. And yet, yes, if you're the guardian or conservator and that incapacitated person has been brought, you can request the out-of-state records on behalf of the incapacitated person. And I would argue it may be your fiduciary duty to inspect those records.
Good to know. So our next question is also about a trust. Does a trust keep everything out of probate? If you have a trust and something my mom signed or a loved one signed prior to death said it goes to the state of, do I need to go to the courthouse and go through probate?
So if you have something that says it goes to the estate of, you're not taking it out of probate. There are legal ways to remove assets from probate. For example, you can have your checking account designated payable on death. So in my case, I am helping my mom. I advised her to take her checking account. She's added me, so I'm a co-owner, so I can write checks in addition to being her power of attorney. And I have advised her to change the beneficiary designation on her checking account to payable on death in equal shares to her then living children. So that takes, for example, $100,000 out of her estate, because it's just going to pass by operation of law straight to the people she names. So if you have a parent that assigns something that says this should go to the estate of, they're just saying it's staying in my estate. They're not even gifting it to a potential heir. There are ways to gift specific things. And I feel like we don't have the time to go into all the different will issues. But you're thinking of the right questions.
Yeah, and I think we should have a podcast in which we just answer this type of questions.
Yes.
Because we have...
I'm happy to come back and do another presentation where I only talk in response to a question.
Perfect, because we have a lot more questions and we are way past the hour. So
I'm fine.
I'm just gonna ask 2 more questions, and then if
Okay.
you're okay with this, I will email you these questions, and whenever you have a chance, if you can reply back, and I'll make sure those answers get to the people who have submitted those questions.
Okay.
So the first question is a guardianship a state or county function?
It's a state function done at the county level. So it's kind of like Medicare. You go to the county office, but it's a state-run program. So if you're a guardian, you do state reporting, but the guardianship springs out of from a county official.
Mm-hmm. And so the next question, it has to do with HIPAA, and this is actually a question that came out a while ago from someone in the community. When you have someone with a mental illness and they have given you power of attorney or a medical advance directive in this case to advocate for you when you are having a psychotic episode, let's say. So this power of attorney agents were trying to get information, medical records on a hospital or from a hospital where this person has been hospitalized, but they were denied. So do you need a HIPAA consent form when you are in medical power?
That is a fabulous question. And my general durable power of attorney and my healthcare power of attorney contains a specific HIPAA paragraph saying that the agent is entitled to any HIPAA protected record. And I think that's the best practice.
Thank you. Yeah, I thought because sometimes, especially with the power of attorneys, there are such a specific language to each one of them that you might think, oh, I can get this, but then it's not covered.
And HIPAA is, it's become a thing in the past 10 years. 15 years ago, I didn't include that language in my powers of attorney. But you just have to be, you have to be vigilant and keep track of trends. So now I include very specific HIPAA language in my documents.
Thank you, Denise. Thank you so much for such a wonderful presentation. We are at the end of the hour, and I want to thank you for your time and for all the knowledge that you have provided today. I will email you those questions. And I also want to thank everyone in our audience for having joining us today. We really appreciate your time. And I'm going to ask you to please fill out our survey because it really helps us provide topics that you are interested in. And I also want to invite you to our next session, which is going to be on Medicare. This is a 2-part session. We are going to have Medicare 101 and Medicare 102 because October is open enrollment. So this is the perfect time. And everyone, thank you so much for joining us. If you have any questions about today's slides or recording, we are going to be sending a link of today's presentation next week so you can watch the recording. And have a good afternoon, everyone. Thank you so much.
Thank you all.